दोस्तों, we have a very special guest today, मिस RV अनुराधा जी. आज मुझे थोड़ा सा संभल करके ही कन्वर्सेशन करना होगा बिकॉज अनुराधा जी इज़ अ लॉयर. शी इज़ ऑल्सो द पार्टनर इन क्लैरिस लॉ एसोसिएट्स. थोड़ा सा आपके बारे में बैकग्राउंड बता देता हूँ दर्शकों को. आपने ग्रेजुएट डिग्री की है फ्रॉम नेशनल लॉ स्कूल, यूनिवर्सिटी लॉ स्कूल बेंगलोर से, एंड इंटरनेशनल इकोनॉमिक्स लॉ डिग्री LLM आपने हासिल की है फ्रॉम न्यूयॉर्क स्कूल ऑफ लॉ, न्यूयॉर्क सिटी से. तो मैं पहला तो क्वेश्चन यही है, थोड़ा सा अपने बारे में बताएं, अपब्रिंगिंग के बारे में बताएं, और मे बी आई विल ऑल्सो रिक्वेस्ट कि क्लैरिस एज ए लॉ फर्म वो किस हिसाब से जो छोटी फर्म्स या बड़ी फर्म्स को कैसे असिस्ट करती है. व्हाट आर द स्पेसिफिक स्कोप of work that the law associate firm takes into?
Okay. Thank you for inviting me for this interesting dialogue. Looking forward to it. So by way of a background, I grew up in Calcutta. I did all my schooling there. And just time pe I was finishing my high school and everything. Law wasn't really a preferred profession. It was because there was no concept of a 5-year law course. This was the late 80s. In 1990, when I finished my 12th, it was really more of an exploratory phase in terms of what subjects one could choose. And at that point of time, the National Law School of India University in Bangalore had just started. It was in its 3rd year of existence. It was an experiment that had been set by Professor N.R. Madhav Menon in terms of making the legal profession a more structured form of education and making it a serious career option. So it's really by chance that I got to know about the place. And once I went there, it really threw open multiple opportunities in terms of various areas of study, various areas of intellectual pursuit.
Wow.
It wasn't really about graduating and becoming a lawyer in courts, but there were options for research, for analysis on a wide area of issues and subjects. So the 5 years that I spent there were extremely rewarding. They really opened up many horizons. It was also the time in the 90s that liberalization was starting, and you may know that it was in the 80s. India was extremely different from what we see today. So in the 90s to mid 90s, when liberalization was just about taking off, there was a lot of change in law and policy at the domestic level, but also in terms of India's engagement in international law. So I still remember I think around 1993, one of the, we had regular classes, and then we also had projects which we had to do, seminar and topics and things like that. So one of the burning issues in those days was what was called the Dunkel Draft.
Dunkel Draft.
Dunkel Draft. Dunkel Draft was actually the genesis of what we understand today as the WTO.
Okay.
So in those days, the Dunkel Draft was called after the author of the draft, Arthur Dunkel. And it was the predecessor of what we understand today as the agreements of the World Trade Organization. And in those days, there was a fair amount of debate, particularly a lot of concern on what was one branch of the Dunkel Draft, which dealt with intellectual property rights. And the reason for that is because one of the proposals for a liberalized set of engagement was that India would need to, if India were to become a party to what was called the Agreement on Trade-Related Protection of Intellectual Property, TRIPS agreement, aapne suna hoga. So that it's something which would have a fundamental impact on one, not just patent protection, but particularly in terms of what it meant for, say, the pharmaceutical industry.
Wow.
Okay, because patents, as you can understand, is a monopoly right. It is to reward innovation. But the actual impact of such a monopoly would be on pricing and affordability. And in a sector like pharmaceutical,
Right.
it'll have significant impact.
Right.
So a number of civil society activists had actually caught on to that implication. And there was a wonderful synergy in terms of activists and lawyers and thinkers in those days to really tease out the complexities of what this agreement is, what should India do for being part of it, what would be the implications and things like that for pharmaceutical, for biotechnology, for agriculture, things which impact people at a regular level. So this was something which we ended up engaging with our professor at National Law School, who was closely working with the government, with some of these organizations. And that was my first inroad into what you called as international economic law. By the time I graduated in 1995, India had become a party to the WTO. This was also the time when liberalization had started having a significant impact. Again, as I mentioned, at one level is the overall international law part of it, but the nitty-gritties of it is really reform in many of our domestic sectors. So dismantling of what was called the license Raj, deregulation, liberalization, privatization in the telecom sector, in the power sector, that had slowly started occurring, and then of course that started translating into attracting more of private sector investment, domestic private sector investment, as well as FDI, the foreign direct investment that started coming in. So this was something which was, we see this period, a lot of it would perhaps at that point of time seem innocuous events. But then once you look at it in hindsight, there are things which you start seeing developing. So 95, WTO membership, then liberalization process starts. Then towards the beginning of 2000s, India's engagement in the WTO as a leader of developing countries, that started magnifying and developing. And then of course this starts, you can start seeing it manifesting into various other offshoots. India's wider engagement in trade agreements, in investment agreements. And of course at the international law, you can't look at it in isolation. So starting from 1992, you would have heard of what was called, since you work in the environmental sector, the Earth Summit, the Rio Summit. Okay? So then 1992, that happened. Then 1997 is what was called the Kyoto Protocol to the UN Framework Convention on Climate Change. And then the aftermath of all of that. So you can see a lot of these developments synergizing and developing together. As a student of law in those days, for me, it was again something which organically developed as graduating from law school. Then I worked for 5 years, and then went for my when I went for my master's to NYU in 2001. It was already a time when WTO had been in existence for some time. 2001 was also what was called the Doha round of development in the WTO, and then some amount of jurisprudence had already started developing, and then the implications of that when it comes to domestic sphere, we had already seen that happening. Winding back a little bit in terms of my career journey, it's something which I don't see something which was planned, but was really more organic. I walked towards what interested me and where the opportunities really were. And as I mentioned, the seeds of international economic law, which started with this project on IPR, on the Dunkel Draft, draft chapter of the TRIPS agreement, and I kept following it, but it's not something which you could say that this is the area I want to practice in. No, it wasn't really something which emerged like that. In 2001, when I did my master's as a global public scholar at NYU, international economic law was one of the main areas that I focused on. And on my return, it isn't again something which immediately saw its implementation in practice. I came back, I worked with, in the corporate sector, I worked with large law firms, including Amarchand Mangaldas and Luthra. And then in around 2007, we decided to branch off and start Claris Law. And Claris is really more of an initiative that emerged from the shared interests of two of us who were the founding partners, and Piyush Joshi and myself. And we started it as a law firm. We kept the name neutral. We didn't associate it with our names, which is traditionally how most law firms would call themselves. And the reason we called ourselves Claris was because we wanted it to symbolize what we believe in, which is really clarity in whatever area that we do. We moved away from big law firms for two reasons. One was to have the freedom and liberty to focus on areas that we are passionate about, without always having the end goal of targets and revenues which have to be achieved, which is important, but it's not the be all and end all. So when we started Claris Law, it was with the vision that we would focus on practice, on the areas like energy, environment, infrastructure, on trade. At that point of time was not an area of practice that I could develop as part of the law firm, but there were a number of interesting studies that were coming out more as consultancy projects to assess the impact and opportunities for India while working on trade agreements, while negotiating trade agreements. So then we ended up working on some projects with the with ICRIER, which is this Indian Council for International Economic Relations, which also works closely with the government. And through that, we ended up working on an advisory role for subsequent opportunities that came up, subsequent, the requirements that really came up on analyzing the potential of trade agreements, what does it really mean for India? And then, as I mentioned, it's just something which organically evolved. And over the last, 15 years or so, the practice again has organically evolved around these areas. We do the practice of law, and I love teaching. So I'm associated as visiting faculty with several national law schools, where I go and speak about trade, about investment, about sustainability, and these are some of the areas which I engage in.
Very nice. So Anuradha, in general, I think what you have mentioned, I think that gives a lot of clarity to us that what Claris as a law firm does. But for the, maybe I think beneficiary side, when I say beneficiary, maybe I think organization like ours or maybe other large corporate firms, when they look at such, maybe I think international trade agreements or the investment opportunities, such things, they look on paper, they are very intimidating, very complex also. So that's where maybe I think maybe one thing that we have noticed कि generally जब हम लोग international opportunities पे काम करते हैं तो there is an agreement which we understand that their law firm has sent us, और उसमें एक maybe I think justice location भी identify होती है, सिंगापुर होता है, UK होता है, and in most of the cases we end up agreeing to that particular location also. And most of the clause that we understand that always maybe I think favor to the client, and I think that is where we understand कि शायद जो यहाँ पे हम लोग small organization या बड़ी organizations हैं, they should actually work with the firms like yours, जो कि शायद इस तरह की चीज़ों में assist करती हैं. They'll have maybe I think a level playing ground available when maybe I think we have maybe the law firms associated with us, because शायद जो डिस्कशन है या लैंग्वेज का जो तरीका है वो दोनों लोग शायद तभी एक दूसरे का समझ सकते हैं, अदरवाइज वो चैलेंज हमेशा ही रहता है. वी मे बी आई थिंक रीड समथिंग, वी इंटरप्रेट समथिंग एल्स, एंड शायद ये जो चैलेंज है वो कितना विजिबल है. मे बी आई थिंक माई क्वेश्चन इज कि यहाँ पे जो एजेंसीज हैं या कंपनीज जो काम करती हैं, हाउ मच दे आर विलिंग टू एंगेज द लॉ फर्म्स. यहाँ पे ज़्यादा लोग, हमारी अंडरस्टैंडिंग के हिसाब से ज़्यादा लोग नहीं करते हैं कंपेयर टू वेस्टर्न कंट्रीज, जहाँ पे मे बी आई थिंक हैविंग द लॉ फर्म इज मे बी आई थिंक वन ऑफ द first activities that the startup or even the established firm does. What is your opinion?
So there are really two levels here. In fact, it's an interesting question because at one level is the nitty-gritty of documents, like when you said that you get an agreement जिसमें आपने जैसे कहा कि वो the jurisdiction clause or the governing law.
Right.
So is it the governing law of India? Should the dispute be settled in New Delhi or in Singapore or in Dubai or whatever? Now, typically, when two parties come from two different jurisdictions, the idea is that if each party may try and push for their jurisdiction for ease, right? Because if you're going to be located in Delhi, and if the dispute is the last thing that anyone would think of when you're looking at a business opportunity.
Absolutely.
You really want to sign the dotted line and get going with it.
Absolutely.
But the dispute part of it is something as an eventuality to plan about.
Yeah.
And a thumb rule really is to look for a jurisdiction which is neutral, which is neither, if particularly if you are dealing with a cross-border partner. If there are two Indian parties, then without hesitation, I would say Indian law and Indian jurisdiction. If it is, something which is with a cross-border client or with a cross-border partner, then to look for a neutral jurisdiction, which is one, going to be economical for you also, because you don't want to have, say, New York and then go there for every dispute or arbitration that were to come up. And equally, that is also a function of how India as a potential attractive place for, say, even because between two private parties, the first option would be, instead of running to courts, try and resolve it through consultation, through negotiation, through arbitration. Right? So how to make that really effective? It's something which you're absolutely right, is not something which parties dwell on as much as they perhaps should in the beginning of a relationship itself. But I think that is changing with I think both sides getting smarter or more aware of what the implications are. That is something which is certainly, which I would urge private sector clients to think about more. But I do see that certainly happening. But there is another level here. There is the question of, here you're talking about the actual nitty-gritty of your agreement, your engagement for something that you are doing. But the type of agreements, when we do, say, the international agreements that India were to engage in, as, say, the WTO or trade agreements, we read in the newspapers, India is now negotiating with UK, with EU, India signed up with Australia, with Mauritius, with UAE in the recent past, say pehle with Singapore, Malaysia, bilateral trade. What does all that mean? And I'm reminded of an interesting conversation with a very senior advocate many years back, and he said, come, you are floating at the stratosphere, come down to the toposphere. And I do realize that it is something which is not part of regular conversations or even part of regular, say, even media coverage, is not really more in terms of the nitty-gritties of these. But the fact of the matter is, many of these agreements that are actually signed at a country-to-country level have significant implications when it comes to the nitty-gritties of how law evolves, how rights and obligations are affected. At a very simple level, if we say that India is signing a trade agreement or an investment agreement, उसका मतलब क्या है? उसका मतलब ये है कि for the private sector, it is symbolic. It's a signaling that two countries are coming together. There is a potential business opportunity because the regulatory framework would be to say that, hey, come and invest here. Your investments will be protected. There is something to gain from this emerging market, and there can be shared opportunities for economic growth and economic development. But at the level of say something like despite a trade agreement having been entered into, when you have certain regulatory measures, which could be from India or which could be from any of our trading partners, which have an implication on, say, India's exports, or which have an implication maybe for India's export, but the spillover impact is going to be on production. How we organize our production systems, how do we actually create a system where we are well prepared. And that is where I feel, that is a second level which still today seems too esoteric, too stratospheric for Indian business or Indian industry to engage with. And this is fairly distinct from, say, when we look at more advanced jurisdictions like the EU or the US, where businesses from day one are actually driving engagement. There are strategy papers, there are policy documents which say that this is the type of clauses, or this is the type of provisions we want in agreements, in trade agreements and things like that. That level of engagement I do not see happening enough. It is changing, but not, it's more reactionary rather than something which you have to anticipate and prepare.
मतलब business as usual का part नहीं है.
Business as usual का part हो जाता है when Indian industry would think that, okay, if a problem arises as a regulation in a trading partner, we will find a solution. We will find a way out of it. We'll have to deal with it. But slowly that the concept that is seeping in more and more is that, to give a more concrete example, when we look at the emergence of, say, carbon tax or carbon price or carbon border measures. These are all very different variety of regulatory measures than what industry has seen so far. And this is something which is emerging because of a very changed perception towards environmental regulation. The more stringent environmental regulation becomes, it has a cost in terms of what sort of mechanisms in production should be incorporated. So to give a small example, you would have heard of what is called the Carbon Border Adjustment Mechanism,
CBAM,
of the CBAM that EU has put in place. Now, this is something which has been in the conversation, I would say, for almost 10 years in some form or the other. And even way back in 2021, 22, post-COVID, when the conversation started increasing in the West, Indian industry was still waiting and watching. We weren't really reacting to anything till the time the measure got enacted. Even then, there is what is now a transitional phase. Even at the transitional phase, whether at the Indian government or the Indian industry, it's been more of a wait and watch kind of a approach, trying to understand what the implications are. It's only like, so October 2023 is when CBAM transitional phase got effected. Okay? And it's only a year down the line that you see the conversations becoming more and more serious. And we are really now close to implementation phase, which is from January 1st, 2026, when Indian products entering the EU market will have to start bearing the CBAM price. Okay? And this is where the actual impact is now going to be felt in terms of actual cost of the competitiveness of the product that it enters the EU market. So at one level, there is a fair amount of positive signaling in Indian industry that we have to prepare, we have to upgrade ourselves. But equally, there is a realization that this is not going to be free of cost, that there is going to be an impact which we'll have to have the government assist us with for the compliance part. But more importantly, the fairness part also, the equity part, where industry is now raising its voice more, that the government should take a more proactive stand, that EU doing this unilaterally has a fundamental fairness issue. And this is perhaps something which should have been addressed in a better not even just bilateral, but in a more multilateral way of doing it. Because the problem that EU is trying to address is climate change that is affecting not just EU. Climate change knows no borders. I mean, pretty much like a COVID virus, it is something which is going to be there everywhere unless we put our collective brains together. So this can't just be a trade conversation. This has to be a climate conversation. It'll have to be, but unfortunately we talk in silos. We have the UN Framework Convention on Climate Change, the Paris Agreement, which the Environment Ministry, a different group of people are having a conversation about. And then we have the trade part of the conversation where the actual nitty-gritty fiscal impact is going to be, which is something which is seen in a separate sphere. And what I see is that gradually this whole debate is converging towards the concept of sustainability as a concept, that you can't see trade or environment separately. This is something conceptually has to be seen together. But the articulation of that is still, I would say, not something which is seen in terms of real world impact. It's more seen as, oh, this is something we have to negotiate here. But how is what we are negotiating here impacting what my competitiveness in this sphere is going to be? That conversation for Indian business is not happening as rapidly as I would want it to happen. And that's something which should, and in a sense, I'm hoping that through things that we write and that we do, we will be able to come down from that stratospheric level to the troposphere, that this is the real impact and this is the way in which we need to address it. Because talking disputes, taking up, okay, एक WTO case कर लेते हैं and we'll have a UNFCCC dispute, these are important to assert our rights. But in terms of actual practical solutions, I think the conversation needs to go more towards India taking a lead in having a agreement that is fair, that can actually take the principles of trade, take the principles of climate change, and propose something which is going to have a meaningful impact, not just for the nation, but for the businesses that are getting impacted by these various international developments.
Very nice perspective, Anuradha. I think I'll also share my perspective as well, because when we work with a lot of such MSMEs or smaller firm or bigger firms जो कि export oriented business में काम करती हैं, so they have a very different understanding. They have some fear also about such clause which is being enforced on them. और उसका एक रीज़न उनको ये भी लगता है कि उनसे बहुत सारा डेटा लिया जा रहा है। और वो डेटा, बिकॉज व्हेन वी वर्क विद देम it is a very detailed, maybe specific, their product, their ingredients, their
where did they source it from,
everything,
the supplier, uska kya hai, framework, so much.
Not only those MSMEs और SMEs firms जो कि डायरेक्टली वहाँ सप्लाई करती हैं, बल्कि जो रूट के थ्रू भी करती हैं. फॉर एग्जांपल किसी ने लेट्स से सप्लाई किया रशिया में या यूएस में, और वो वहाँ पर EU में सप्लाई कर रही हैं. वो रिक्वायरमेंट क्या है कि बहुत सारी जगह पे हो रही है.
करेक्ट.
और वो जो नॉट ओनली EU जहाँ पे वो CBAM का स्ट्रक्चर उन्होंने इन्फोर्स किया है और वो 2026 से एक्चुअल इम्प्लीमेंट भी करेंगे. बहुत सारे जो उनके बायर्स हैं वो अब उस तरीके की या सिमिलर तरीके की रिक्वायरमेंट रखते हैं। तो जो फर्म्स का इंटेंट यही है कि मतलब वाई नॉट द गवर्नमेंट टेक्स देयर स्टैंड और उनके बिहाफ में, क्योंकि हमारे मिनिस्ट्री ऑफ एमएसएमई भी है, हमारे यहाँ पे एक स्ट्रॉन्ग मे बी इंडस्ट्री रिप्रेजेंटेशन भी हो सकता है। जब इस तरह के लॉज इन्फोर्स किए गए हैं या इन्फोर्स होने की प्रोसेस में हैं, जो कि उनको भी लगता है कि वो शायद वो WTO की जो प्रिंसिपल्स हैं उसके खिलाफ हैं वो, तो दैट इज़ वेयर वी थिंक आई अंडरस्टैंड, बिकॉज मे बी आई थिंक आई थ्रू द ऑर्गेनाइजेशन ग्रीन ट्री वी वर्क विद देम, और हमें लगता है कि उनका कंसर्न बहुत ही लेजिटिमेट कंसर्न है। और इस तरह के केसेस में जो मे बी लॉ फर्म्स हैं जो शायद इस तरह के एग्रीमेंट को वेट करती हैं या इस तरह के इन्फोर्समेंट को मे बी आई थिंक मे बी अगेंस्ट मे बी कहीं अपील कर सकती हैं, वो सब प्रोसेसेस भी शायद चली रही होंगी। दैट इज़ व्हाट वी अंडरस्टैंड कि शायद जब इस तरह के बायलैटरल एग्रीमेंट्स हो रहे हैं या इन्फोर्समेंट हो रही है, कुछ आज के टाइम में इंडिया एज ए नेशन एक में भी आई थिंक वेरी वोकल कंट्री भी है, अपनी चीज़ों को रिप्रेजेंट भी सही तरीके से कर लेते हैं। तो उस तरीके से शायद जो हमारे यहाँ की जो इंडस्ट्रीज़ हैं उनका सेफगार्ड बहुत ज़रूरी है। अदरवाइज़ मुझे लगता है कि इंडस्ट्री शायद वो अपने यहाँ की इंडस्ट्री सेफगार्ड करने के लिए ही इस तरह के रूल्स रेगुलेशंस को उन्होंने इन्फोर्स करने की प्रोसेस में है। और जो यहाँ पे बिकॉज वी आर कॉम्पिटिटिव, वी मे बी इक्वली क्वालिटी कॉन्शियस, बट शायद वहाँ के जो प्राइस पॉइंट है यहाँ के प्राइस पॉइंट में डिफरेंस है, इसीलिए यहाँ पे जो ऑर्गेनाइजेशंस हैं दे गेट फेयर चांस टू सप्लाई टू दोज कंट्रीज। वो शायद जो एक फेयर ट्रेड या अपॉर्चुनिटी का जो तरीका है या WTO के जो एग्रीमेंट पॉलिसीज हैं उनके खिलाफ भी है वो। तो मतलब जो आप कह रही हैं इट मेक्स वेरी वेरी सेंस टू मी कि शायद वो बहुत ज़रूरी है और वो इंडियन गवर्नमेंट को इन सब चीज़ों को लेकर के बहुत ही सेंसिटिव तरीके से आगे बढ़ना चाहिए।
So there are two things here. Now, आप जो बोल रहे हैं conceptually you are absolutely right. Now the point is that government is certainly sensitive to all of this and they are doing. But the point is also, and it's a very crucial point that you made, that in a measure like CBAM, it is not going to be EU specific. EU शायद implement कर रहा होगा, लेकिन the actual impact which you're saying even from MSMEs to range of businesses, small, medium, large, will be facing is the requirement of and you hit the point pretty nicely, that data collection. That is, how is your supplier producing? What sort of emissions were there at that supplier's end? What is the data relating to all of that? Because the granularity of it is something which, unless every industry has. I mean, these days you understand, nobody works in isolation. It is really a very, very nicely globally interconnected world that has actually emerged because of global agreements and things like that. But here we are going to face a situation of, you also hit the problem correctly in terms of how is it going to impact competitiveness. Okay. And here we're really not talking about, there is one way of dismissing it to be saying that, if you can't manage the fair carbon price, that means that you're a polluting industry. No, that's not the correct way of looking at it, because carbon price is something which is not universally determined. It's really a question of, it's going to be determined by a variety of situations. आप environmental sector पे काम करते हैं, so you know very well that it is not that carbon dioxide emission is free in India, not at all. You work on different regulatory instruments such as energy efficiency, for which you have the PAT scheme, the Performance Achieved Trade Scheme under the Energy Conservation Act and the Bureau of Energy. Then you have the CERC, the Electricity Regulatory Commissions, which have put in place the Renewable Purchase Obligation under the Electricity Act. Okay. Now, and then related to that, you have the REC, the Renewable Energy Certificates. So each of these, they are two, I would say, concrete examples of an implicit price on carbon, which is there. Okay, but this is not translated into an actual per ton price of carbon dioxide emission per se. Other than this, industry by itself, so many industries, whether it is small, medium or large, they are doing their own sustainability initiatives, which is also not necessarily, I would say, concretely monetized in terms of, what is going to be the price of this. Other than this, you have a variety of other taxes that all industries have to bear. What is absent in India is the articulation of what is that implicit price of CO2 emission or the explicit price. And what EU is doing is to say, because their carbon dioxide emissions is tied to what is called the emission trading scheme, the ETS scheme, which they have had in place for many years, jiske andar the obligations on their industry has been progressively increasing. Earlier, they used to have a large amount of free allowances that would be given to energy-intensive sectors. But and see, this is where there is a very clear relationship between EU's obligation under the UNFCCC, under the Paris Agreement, and what it has to do domestically. So under the Paris Agreement, every country has said that this is my nationally determined target to reduce carbon dioxide emission. So if EU has to meet that target, it necessarily needs to implement it internally. It's the same thing with India, which is the reason why you have greater investment in India, for example, for renewable energy, for greater energy efficiency. India has now put in place what is called the carbon credit trading scheme. So all of that is evolutionary. Similarly, with EU ETS, they have to implement it. As a result, they are essentially having to reduce the free allowances that were impacting their energy-intensive sectors. Kaun se energy-intensive sectors? Iron and steel, aluminium, cement, fertilizers, hydrogen, etc. If they have to reduce, that means that their energy-intensive sectors, their price of emission, the emissions that they have to bear is increasing. So the carbon border adjustment measure that they have articulated now is really going to be based on the price that their domestic industry is having to face. Okay. So what EU is saying is that EU ETS ke andar, the price of carbon dioxide emission that is determined as the price that an EU producer has to pay, that is the price which will be the basis for determining the CBAM price. Now, when an export from India enters EU, at the border, there will be an assessment of how much carbon dioxide emission price has been paid in India, and then subtracted from the CBAM price that EU is paying. So, in other words, EU price is taken as the benchmark. What you pay here is subtracted, and the CBAM price has to be paid there. Effectively, ho kya raha hai? They are using one benchmark, one carbon price as determined within EU. Jabki India mein, as you know from the industry perspective, CO2 emission is not free. There are a number of implicit prices. Whether we'll be able to convince and get those subtracted from the CBAM price is one point. But even assuming we manage to subtract all, whatever is paid here, whether we should be paying EU the difference of their price, is that a fair price which can be seen to be applicable in India? And I would argue no, because the carbon dioxide emission price in India will have to be determined internally, and it will be different from what EU has to pay.
It will be less costly also.
It will be less costly.
Yeah.
Now, this fundamental aspect is something which necessarily needs to emerge in the form of a global agreement on carbon pricing, that countries agree that, because we have differential targets. And why is it that we have different? It's not a matter of accident. It's a matter of a global agreement. A global agreement under climate change where there is a clear recognition that industrialized countries have a higher burden to bear, okay, because of a higher level of pollution there. Okay. In fact, if you actually take the debate down to say per capita emissions, India is one of the lowest.
Yeah.
Okay, and it will be much higher there. So there are a lot of practical, philosophical, and extremely important legal issues which need to be resolved at this point of time. So if you were to ask me that, is the Indian government doing sufficiently? I mean, yes, we are. You're absolutely right. We are one of the, the most articulate. We are taken far more seriously. We have been the voice of developing countries. But do we need to do more? And absolutely yes. And that more needs to also be driven by the understanding of the industry, the demand of the industry, because it is not sufficient for industry to rely on, or businesses to rely on, government will take care of things. No, I think that the government will know more once the industry supplies that information, that practical experience of what is it that these measures are going to translate into. Government on its own may not be able to fathom.
उसके पास information नहीं हो पाएगी.
Information and industry asking the government कि हमें subsidize कर दो, हमें पैसे दे दो for compensating for the CBAM audit, data collection, that sort of thing is also not an answer.
Yeah.
We really need the solution to be far more evolved, more in terms of, that is where I meant that looking at global developments, how is it going to impact at the actual production, the cost of production, the competitiveness, the price of export, anticipating that rather than simply reacting to it after CBAM has got implemented. Today we're talking one measure, but there are already news about US, Canada, Australia, who are going to be implementing this. And UK also, and that's something which we need to anticipate, and not just at the level of the large industry organizations, but as you said, the MSMEs, which need to understand the impact, because they are not going to be insulated from these global headwinds. Global headwinds are going to come, and how do we translate the impact of the international to the domestic, rather than wait to react कि अच्छा हो गया है अब क्या किया जाए. Not that, but really, can this development be arrested? Can this development be postponed till the time that countries talk more logically? So I mean, one would actually think, as I keep thinking, climate change is something which needs a conversation not just at a UN convention. It really needs a conversation of different levels at the domestic, local sphere and the government. And again, at the government, it can't be silos. It's really more environment and commerce coming together, because it is something which impacts both.
Multi-stakeholders have to be involved in the discussion.
Absolutely.
Otherwise, maybe I think we also look at it not only in terms of maybe I think optimizing the carbon emission perspective, but we also look at it as an earning source for the EU.
Absolutely.
Because they also understand that India as a nation is growing with respect to the industrial output.
Correct.
And then maybe I think they may not be maybe I think so much ready with that, maybe I think energy and the preparedness, but through this they can always earn a lot of money.
You're right. I mean, if it is going to should it really go to the EU exchequer, this difference in price, or should it actually be translated into a fund, a climate fund, or a technology development fund that comes to India because we are really facing a dual challenge of the need to have economic development, enhance economic development, enhance the availability of energy in a sustainable way. Okay, we can't afford to pollute, because it is our common sense that we have to do it. You are in this industry and you will understand more than anyone else that the technology exists, the knowledge exists, okay, but it's going to have a cost. It's expensive.
Yes.
Right?
Yes.
It needs to be operationalized through incentives, through technology transfer, and through a mechanism which can actually facilitate affordable technologies, right? So, that dialogue, that conversation really has to come in. If you're going to end up paying the price to another country's exchequer, that objective is not going to be achieved.
Yeah, so I think one of the maybe I think discussions that we were having with the industry body And then they were also emphasizing this, that if there is a specific, let's say, enforcement of, let's say, this law there, maybe as a CBAM I'm talking about, then why don't, maybe I think we have a equivalent, certification kind of thing, which they recognize, so that we should not, maybe I think, share such information. The certificate itself has all the information. If, let's say, India
says that this
is certified, it means that they have to agree.
Correct. But for that, we need a mechanism here first, and then negotiate.
Yeah, absolutely.
And then have the recognition, equivalence
recognition. Yes.
Yeah, you're right. But equally, it is also a thing of nothing different from, say, when the world got together to develop the polio vaccine to eradicate polio.
Yeah.
Or when the world got together with some difficulty on the COVID vaccine,
Absolutely.
because again, this is something which, viruses which know no borders, okay? And you need collective action to actually resolve it. Climate change is no different.
No different, yeah.
So when you say here you're talking about the equivalence in terms of the actual measurement and
Absolutely,
data, but equally more in terms of the ways in which you can access technologies, more energy efficient technologies, better renewables, substitutes for, say, plastic, a whole lot of actions down the value chain. To kind of operationalize that, there is necessarily a need to have a repository of where the technologies exist and an effective mechanism to operationalize that transfer of technologies, right? And this is something which conceptually sounds good, but there really is no concrete mechanism which, other than initiatives from, say, the World Bank, from a few other international organizations, there is really no multilateral effort to tie all of this together. There really should be no unilateral CBAM. There really should be that countries come together and say, my problem is your problem, how do we resolve it?
Yes, I think I think sometimes fail to understand that maybe every year there is a COP, and then a lot of, I think hundreds of thousands, maybe I think stakeholders, they visit and make a lot of discussions, and it is a worldwide festival in terms of people coming and discussing. And then ultimately, maybe I think sometimes some things that we see, maybe I think from outside, looks very simple. Why don't they come up with such simple solutions, so that maybe I think the overall motive or the intent of, maybe I think reducing the GHG emission or reducing the carbon dioxide in the atmosphere should get fulfilled.
Correct.
Otherwise, maybe I think this is just, maybe I think, another way in terms of the bilateral trade or the business, because we understand that if we are a developing nation, then we really need the technical assistance. We really need the maybe innovation that has already been done.
Yeah.
And then if we have that technology available, we can always, maybe I think, progress faster.
Absolutely.
And this looks very simple also.
And you're right, and you're absolutely right that, in fact, in 2009, when countries came together, there was actually this famous global pledge that, $100 billion per year by 2020. And today the estimation is that no, it is actually closer to 1 trillion.
Yeah.
And more importantly, we have these absolutely stunning reports from the Intergovernment Panel on Climate Change, IPCC. Which brings out, what you essentially said, that these are, it brings out a few things very clearly, that there is an abject failure to meet this 100 billion target, forget the 1 trillion target, So that's something which we have, that countries have failed to meet. But the irony is that solutions exist, technology exists. Okay, it's accessing that which needs greater financing and greater technology transfer. And I agree with you that why is it that governments are finding it so difficult to translate intent to action, particularly when solutions exist. One problem I see is because a lot of these solutions are available with the private sector. And well, like it or not, private sector is going to be looking at things with a certain vision of a business and a profit motive. I'm not saying that's bad, but that needs to be blended with more of, how do we maximize the outreach, because that itself can have an implication in terms of growth and opportunities. So the conversation, I mean, of course, way back in the 50s, I keep getting reminded of, when the polio vaccine was developed, Jonas Salk, when, he was asked, are you going to patent this? And he said, no. His famous response was, can you patent the sun? Okay.
Wow.
And then he said that his intent was to have this accessible to as many people as possible to get rid of polio. Subsequently, when Dr. Sabine came up with his another vaccine, okay, it was he also followed pretty much the same path. This is in the 50s. Okay? When you come to COVID vaccine, that really it did not really translate into, although India did try to work out a COVID vaccine IPR waiver at the WTO at that point of time, it wasn't a complete success. Okay? It's something which did have a fair amount of qualifiers and disclaimers and things like that. And when we come to climate technologies, I would say that I'm not saying IPR is the only barrier. It is a question of access, information, and the financial ability to fund the transfer of technology. And this is something which I believe necessarily has to be part of the conversation, not only at the UNFCCC, but at the WTO. And perhaps, the best would be a international sustainability agreement that can bring both these streams together.
Absolutely. Yeah.
Okay. And then, because instead of having targets under UNFCCC unmet, if we are going to use unilateral measures, trade measures, which, as you said, are pretty much flying at the face of the logic of rights and obligations, not just of WTO, but of the UNFCCC, right? Because if you're going to say unilateral carbon price, that goes against the concept of nationally determined contributions and common but differentiated response, all of this. It's actually against both spheres of commitments. But how do you resolve that? Unless you kind of come together and have a vision for addressing it in a sensible platform. And I completely agree, if solutions exist, there is a famous saying which is that where attainable solutions exist, ignorance has the guilt of vice. Okay, that you're actually doing a disservice to humanity by trying to do a one-upmanship rather than find a collective solution. And that's something which which it's not really more an India problem or a EU problem or a US problem. It's really a global problem. And I hope that, there is COP29 coming up in November this year. But unless the conversation enters the sphere, because CBAM is still seen more of a WTO argument rather than a UNFCCC argument. So unless that conversation enters here, because as you're saying, it is going to start impacting Indian businesses, and the time is ticking, the clock is ticking.
Already, I think voluntary phase में चल रहा है, it will become mandatory.
Data phase तो चल ही रहा है, which is why you are meeting clients who are facing that problem, who are facing that pinch. Now, once it enters January 2026, and once CBAM now is for 6 sectors, iron, steel, aluminium, so on and so forth. But it will start getting implemented for downstream products. And that is something over the next 3-4 years, unless there is a very clear-cut solution that you cannot have a uniform carbon price, and if Indian producers paying Indian carbon price, you will not be penalized at the border. There has to be that recognition. 2, there has to be a clear agreement on where do, at least a repository of information of where do clean technologies exist, how do you access that, and how do you make it affordable? Because development is something all of you need to do together. And if you don't, then it's really going to be, it's not just a question of equity and justice, but the fact is that it's going to be a failure of institutions at multiple levels.
Absolutely. Since it is also very much like maybe visible that climate change has no boundaries.
Exactly.
जो इंडिया में इश्यूज दिख रहे हैं वो ईयूज में भी दिख रहे हैं, यूएस में भी दिख रहे हैं.
Exactly.
रिसेंटली ओलंपिक में यू मतलब इट वाज अ न्यूज,
one of the hottest Yeah.
location.
Yeah, correct.
So Anuradha, maybe I think changing from this discussion to maybe international trade and the investment, some discussions हम चाहते हैं उसमें भी हो. तो for example, there are two examples I'll take. One example where it is linked with the geopolitical scenario. So for example, recently we have also seen one of the maybe I think news कि जैसे under the bilateral trade agreement के through अडानी जो हमारे यहाँ पे इलेक्ट्रिसिटी सप्लाई कंपनी है उसने बांग्लादेश को सप्लाई किया, एंड देन देयर वाज अ मे बी आई थिंक ड्यू ऑलमोस्ट लाइक $500 million जो कि बांग्लादेश को अडानी को देना था. सो this is one example. The second example, maybe I think last week, Dr. Ajay Mathur, who is a Director General International Solar Alliance से वो भी आए थे, and then he was also mentioning that maybe I think India requires a lot of investment with respect to the solar, because the kind of commitment that we have given and are claiming कि इतने टाइम तक 2030 तक हमें 500 गीगावाट का इंस्टॉलेशन करना है, which is inevitably requires lot of investment from maybe international firms to India. इसका मतलब है कि उनको भी गारंटी चाहिए यहाँ पे, गारंटी इन टर्म्स ऑफ गेटिंग देयर मनी बैक विद द रिटर्न एक्सपेक्टेशंस. तो ये जो पार्ट है, चाहे वो हम इंडियन कंपनी बाहर कर रहे हैं और वहाँ उसकी एक्सपेक्टेशन है दैट उसका इन्वेस्टमेंट सिक्योर रहे, सेफ रहे और रिटर्न्स उसके आएँ, इवन इफ देयर इज़ सम इशू विद रिस्पेक्ट टू देयर इंटरनल चैलेंजेस, या बाहर की कंपनी इंडिया में आए और फिर उनका जो सेफ गार्ड रहे. इन दोनों ही सिनेरियोज में ये ज़रूरी है जो आपने भी पहले बोला कि गारंटी या उनके जो इंटरेस्ट है उसको सेफ गार्ड होना चाहिए विद रिस्पेक्ट टू द मे बी द एग्रीमेंट्स जो कि अंडर बायलैटरल ट्रेड के थ्रू हों या इन्वेस्टमेंट के थ्रू हों. हाउ कॉन्शियस वी आर इन टर्म्स ऑफ सच एग्रीमेंट्स, या इस तरह के कितने केसेस हैं जो अभी आपको लगता है कि मतलब इस तरह के इन्वेस्टमेंट को इन्फ्लुएंस करते हैं? इंडिया की कैसी रेपुटेशन है इन सब एरियाज़ में इन टर्म्स ऑफ maybe think flouting such agreements which are there? तो इस तरह का कुछ सिनेरियोज आपको
See, I think from a very practical standpoint, what does an investor look for? Investor will look for a good market opportunity, okay? Will look for a fair regulatory framework, okay? That there is not going to be too much of change in law and policy, okay? Predictability, and easy access, smooth. And in a federal structure like India, this is it will have its challenges, its complexities, because for example, even if you were to look at something like say electricity, it is something which say under the constitutional framework falls under the concurrent list. मतलब दोनों center और state का उसके ऊपर they have the ability to do the
agreement होना चाहिए
और legal framework के ऊपर दोनों का. तो you have the CERC, the SERC. To give an example. जी. Environment जो है, it is something which is something that is being driven at the central level, okay? But the actual implementation, you have the the pollution control boards which are there at various levels and things like that. Something like access to land, you were mentioning solar projects, okay? For solar projects, that for say PV or the photovoltaic cells, you would perhaps need lesser amount of land, but for say thermal projects, you will need access to land. Any industry will need access to water, electricity, roadways, infrastructure, things like that. So here again, what I mean is that there is a level of signaling that you do at the central level, and then what states have to implement, in terms of welcoming the investor, that यहाँ पे land है, यहाँ पे आप setup कर सकती हो. This is the, well assured, ease of access, of doing business, which ease of doing business का मतलब क्या है कि आपके पास you have access to land, to water, to electricity, to whatever other permits you may need. You're not constantly, waiting for some clearance to come up. It's something which can be facilitated. So a number of things can be done through this synergy between center and state governments, which is happening, which is already happening, and which like for example, by way of signaling, so many states in India have started putting in place their own renewable energy policies.
Yeah.
Including for solar separately, या फिर renewable energy policy as a whole, which is a signaling for an investor that you come and we will have a platform for you to invest, and it's essentially you are contributing to the development of a very critical sector, and there is going to be a return out of it. In terms of actual nitty-gritties, there are a number of agreements which will be there, say with the state, with the government. It can be backed up with a lot of, I'm not talking international, essentially agreements in terms of state guarantees, in terms of the support agreements that can be done and things like that, all of which can essentially secure the interests of the investor in a fair manner. And of course, most industries have started becoming more astute now to particularly in, as you mentioned, say Bangladesh or any other country where a private investor is investing in, to look for political risk insurance. Okay? This is something which is also something just factored as part of a business decision.
Okay.
So when a company is doing due diligence, they are looking at the whole gamut of issues in terms of you raise two scenarios where investors being attracted to India, and I would say for investors being attracted to India, the government is doing a lot of things which is signaling or giving the right signals. And in terms of how can this be further accelerated, it can perhaps be done through not just monetary incentives, you have the PLIs and all of that, but also a fair amount of assurance in terms of states coming forward for single window clearances to set up your plants, having some kind of an incentivizing of, if you're saying solar ke liye hame chahiye, to, how do you actually attract and retain investment in that sector? Equally, it is about the technologies, which is again, as I mentioned, where do the technologies exist? Wo kaise, how do you bring that into the country? That is, how do we target those investors or those entities which are specializing in technologies that we want to come into India? So that is also something which the government can start working towards. In terms of what is it mean in terms of, say the example that you gave of the situation in Bangladesh and the fact that there was a fair amount of outgo for an Indian company, how can that be addressed? This is something because of, see, a geopolitical risk is something which is inherent. And here I'm one line of thinking among, one school of thought here is that you can perhaps have, leave it to the investor, leave it to the private investor to have a recourse to the government where it's investing through what is called investor to state disputes. Government of किसी government को आप international tribunal पे ले जाओ and you have a recourse there. This is something which India has also tried, and we have a few agreements where foreign investors can take the Indian state to an international tribunal, what is called investor to state dispute settlement. I'm honestly not in favor of that for a few reasons. Okay, one is that it is, when an international agreement is being done, it is really between two governments. And it should really be, in my view, from a standpoint of overall concept of how international agreements should evolve. International agreement should be between two states, and the type of signaling that happens to the private sector is through that agreement. So, for example, say trade agreements में, WTO agreement में, if there is a dispute between two countries, they take it to the two governments take it to the WTO panel. लेकिन कुछ इन्वेस्टमेंट ट्रीटीज इंडिया ने साइन किए थे whereby which gave rights to the private investor to take India to an international tribunal. And one of the first cases that had come in this regard was something called White Industries case, when an Australian coal supplier, machinery supplier, not coal supplier, machinery supplier to Coal India, got an अवार्ड, फेवरेबल अवार्ड, लेकिन वो एनफोर्स करने में टाइम हो रहा था बिकॉज ऑफ विद इन द इंडियन लीगल सिस्टम थिंग्स वर टेकिंग टाइम, एंड दे टुक इंडिया टू एन इंटरनेशनल bilateral investment treaty dispute settlement. Okay. Sounds a little esoteric, lekin there was a significant award against India in 2009, and that was the first case against India. You asked me how many such cases have come, and there have been quite a few since then.
Wow.
Over quite a few since then, which have emerged for various reasons. The most recent one, I would say, which got settled was when you would have heard of this retrospective taxation. So this was a case when there was because of a change in India's tax law. There was an impact that companies like Vodafone, like in India, had to face. Unfortunately, it could not get resolved internally, domestically, and Vodafone and Kane actually preferred an international arbitration. But again, luckily that got resolved through a bilateral settlement. The government said that, okay, we can settle it, and then they changed the laws and it got settled. My view is that these kind of issues, there should be a mechanism to resolving it without going for a dispute settlement. There has to be a investor redressal mechanism, like an ombudsman, or a mechanism to facilitate a grievance redressal. And this can be built into agreements. And in fact, there are some agreements that India has been entering into of late. One example is that of India-Brazil investment facilitation and cooperation agreement, under which there are 3-4 levels. There is a mechanism whereby even at the time of investment, if there are any bottlenecks, anything where the government can facilitate, there is an opportunity to go and get it resolved. Why allow a fight to brew? If a simple problem can be fixed, fix it. Because ultimately,
time chala
jata hai, cost, and it is your and my taxpayers' money. Right? So try and resolve it, because what is the purpose of the investment? It's for development. So if you're going to look at it from a very proactive perspective and have clear rules and mechanisms, I really feel most disputes can get resolved at that level. So if you were to, I know I haven't given you a direct answer for how Adani can recover from the government of Bangladesh, but my point simply is that it potentially could have been resolved had there been a facilitative mechanism whereby, there can be a government-to-government engagement to find a resolution, rather than have a situation of a private company dragging a government to an international tribunal. Because what is happening across the border is something which has its genesis in geopolitical, climate, geopolitical risk. It's not a hostile government. It is something which hopefully can get resolved, if not immediately, then over a period of time, in an amicable way. But my point is that when you're talking about investor-friendly mechanisms that India should put in place, it should really be more in the form of grievance redressal, conciliation, and internal mechanisms to prevent disputes, rather than allow a dispute to happen and then say, what do we do about it? That sort of thing.
थोड़ा सा सिंप्लीफाइड वर्जन होना चाहिए. एमिकेबल एड्रेसल मैकेनिज्म बहुत ज़रूरी है. समटाइम्स मे बी आई थिंक द प्रोसेस इटसेल्फ इज सो कम्बरसिव कि शायद लोग, या तो कुछ लोग जाते नहीं हो, जाते हैं तो शायद उसी में फंस जाते हैं.
Exactly. So, absolutely. You're absolutely right. Either you give up or you spend too much, and then it has other repercussions.
Absolutely. Very very I think interesting perspective, Anuradha. थोड़ा सा और चेंज कोर्स करते हैं डिस्कशन का. Maybe I think some lighter version of the discussion, a rapid fire round. It is, we call it. So, what is your favorite book on law?
Honestly, you've caught me there. I can't think of one favorite book on law, but I would say the Constitution of India. It's not a book; it's the fundamental text, right? But yeah, that's pretty much my favorite go-to book.
And who has been your biggest professional influence?
I would say my professors. In fact, I can easily name 3 of them. One is Professor N.R. Madhav, who, as I mentioned in the beginning, had started National Law School. Then Professor N.S. Gopal Krishnan, who was our professor of intellectual property rights. But he had a very interesting way of teaching the law, making it accessible, and also making us look at the interrelationship, as I mentioned, between the domestic and the global. And the third person is Professor Joseph Weiler. He was my professor of international economic law at NYU. And he's the one who made us understand again the repercussions of global developments and how it impacts domestic. So yeah, I would say I would count the 3 of them as my greatest sources of inspiration.
Very nice. When you are given a chance कि आपको digital या print media में दोनों में से option कोई एक pick करना हो in terms of reading the legal material, तो which one will be your pick?
Well, the digital is certainly more accessible today, but nothing can match the benefits that you can get. I'm very old school. The benefit that you can get from holding a book, turning the page, marking with a pencil, कि ये important है. So I would say, for me, the print media holds perhaps equal amount of importance as the digital.
And do you think people can learn law as a field from the online mechanism?
I think the online mechanism has a lot going for it because the access is amazing, right? So it's the reach. You don't have to enroll and be there physically. So the outreach is far more in the digital sphere, but it can only supplement. It cannot substitute the actual nitty-gritty of being in a classroom physically and interacting and having dialogue and discussions, because that is really the best form of learning, and I don't think there's a substitute for that.
Wow, okay. And maybe I think if you have the maybe potential to think in terms of कि एक ऐसी hypothetical scenario जब आप law नहीं कर रही होती, then what could be the alternate option for you, or what could have been the alternate option?
I would probably see myself as a doctor, okay, and I particularly in the area of psychology. I think that's one of the fields which fascinates me, and perhaps that would have been an alternate career option had I not been a lawyer.
Why psychology?
The way the human mind works, how it perceives, how our thoughts guide decision making, and very interestingly, I actually see a synergy now of late between psychology and law because so in fact even when you take the question of why nations act the way they do, it is embedded in perceptions, and that's something which is inherently governed by the way the minds of individual actors perceive certain situations and how it impacts. So that's one of the areas which I hope to perhaps even now work on.
Yeah, I totally agree. The psychology and the law as a practice is maybe I think very much like correlated also. No?
Yeah.
So maybe I think in general what we see as a maybe I think a normal human being, maybe law as a practice requires a lot of discipline and the skill or grip on the communication. मतलब कुछ समय हम लोग भी देखते हैं मे बी एटलीस्ट इन द व्हाट्सएप फॉरवर्ड्स कि जो हमारे ऑनरेबल चीफ जस्टिस ऑफ इंडिया DY चंद्रचूड़ जी हैं, and then he get furious number of occasions and ask the maybe I think opponent or proponent in terms of कि आप अपनी वॉइस लो करिए और so I think such scenarios are part of the aggression or maybe I think generally this is a मतलब जो कोर्ट का जो एक तरीके का एक प्रैक्टिस है कि सभी को अपनी तरीके से बात करनी है और लोगों को बात नहीं करनी है, सिर्फ लॉयर्स बात करेंगे या जज बात करेंगे, तो उसका जो डेकोरम है उसको लोग जब भी मतलब तोड़ते हैं तो शायद ऐसा लोग बनते हैं. तो मतलब वी अंडरस्टैंड दैट दिस इज अ वेरी वेरी मच हाई डिग्री ऑफ डिसिप्लिन एंड मे बी आई थिंक अ ग्रेट लेवल ऑफ कम्युनिकेशन भी है. मतलब एज अ पार्ट ऑफ द प्रैक्टिस इट इज one of the maybe I think major requirements.
Yeah, no, that's true, because at the end of the day it is about communication and how do you reach to a judge the point that you're making. And court craft, you're right, often gets associated with dramatical, theatrical kind of performances, and but the point that you're making in terms of basic courtesy, basic decorum, and how that is crucial to get a point ahead and point across is part of any lawyer's way of projecting an argument. So that's I agree.
Maybe I think somewhere in terms of the practice again, I have maybe a question. जैसे we have seen some maybe I think celebrity lawyers जैसे हरीश साल्वे जी हो गए, कपिल सिब्बल, लेट अरुण जेटली सर, बहुत सारे ऐसे नाम हैं जो कि मतलब राम जेठ मलानी सर हो गए जो कि बहुत फेमस हैं. दे आर मे बी आई थिंक रिप्रेजेंटेशन ऑफ द आईवी लीग लॉयर्स हैं. हमारे यहाँ पे जो फर्म्स हैं वो बहुत ज़्यादा बड़ी नहीं होती हैं. आई थिंक द पर्सन नेम जो है वो बहुत बड़ा होता जाता है. तो जो बड़ी फर्म्स बनाने का जो तरीका है इन टर्म्स ऑफ लॉ एज ए प्रैक्टिस, वो इंडिया में मतलब इन जनरल नहीं है, या मतलब जस्ट बिकॉज इट इज़ मे बी आई थिंक इंडिविजुअल डिलीजेंस ड्रिवन फील्ड है ये या प्रैक्टिस है. लोग कॉरपोरेट फर्म्स की तरह नहीं ज़्यादा बड़ी करते हैं.
See, I think it's two slightly different things. जो corporate firms है, in fact they are growing in size, and it's more a sign of whether you want to be small or large is often a question of the type of work that you want to do, and the type of practice that you want to do. When it comes to actual court-related litigation, etc. However, whether it is India or any other country, it is about individual practitioners. Now, then the question is, why is it that some individuals are so famous? Okay. And that's one organic.
मेरा उससे क्वेश्चन ये था कि वो इतने फेमस हैं कि मतलब for normal people they are unaffordable.
Agreed. And I think that has to change. Okay, and that with more and more younger people getting into the profession, with more recognition of the talent of youngsters, because there is, I would say, a little bit of misconception that judges listen more to the senior advocates, the name that they carry and the weight that they carry. Experience counts, of course, undoubtedly, and they're brilliant lawyers, each of the people that you mentioned. But the fact is that it's that aura of supremacy is something which can only get dented over a period of time. And I think gradually, I would say, a lot more younger people are getting their voices heard. It's a function of both the judiciary listening and encouraging youngsters to come up. Okay, and I think Justice Chandrachud is one example. He actually encourages younger lawyers to speak up. So do a number of other judges at High Courts and Supreme Court, saying that we don't want to listen only to the big names, but to the younger ones also. So that's something which I think will organically evolve as well.
Very nice, very nice. I think that is what we also wish that maybe I think because this is very, very important aspect. We run an organization, so we understand that how important such a component is for our practice. And then we really feel that maybe I think with more firms, bigger maybe I think pursuits in terms of the people and the organizations, maybe I think it would become more democratized. It will become more
I think that's a good word.
Maybe I think more affordable for the organizations. Otherwise, maybe I think it's really difficult sometimes, because in India in general, maybe I think services are very cheap. So that is where, compared to maybe I think other countries. And that is where we feel that this is also one of the service which is very, very important service, I think. Because the moment you ignore the maybe I think clause or the terms in the agreement, you end up losing a lot of money in the worst case scenario. So maybe I think that is my wish. So, but maybe I think the last point, Anuradha, I think this is one of the one of the best conversations that I have. Maybe I think this is something which we do not know much about. That may be one of the reasons. But maybe I think for our listeners, we really want that they could listen your certain milestones in terms of Claris as a law firm, and then they could also understand and get inspired from your maybe I think success stories and the milestones that you have in your life journey and the Claris as a firm.
I'm very bad at self-promotion. So I think just actually honestly grateful for life to have thrown the opportunities it has, and to the fact that I keep joking with my partner that this is pretty much the longest career that we've had, having created something which has survived and which provides a nice space to do good work, to actually do the practice of the law and to teach, both of which I really love, and write, which I should do more often. So I would say it's really more a question of organic growth, organic development, doing what we felt intuitively is right, and looking at opportunities and being grateful for that. So all said and done, I think really the fact that we are here is something to celebrate, not really from a perspective of milestones, but the fact that we exist. Okay.
Perfect. Thank you so much for your time, Anuradha. I'm sure we'll certainly be inviting you again for a lot of I think climate change and environmental perspective, where we really feel that it has to be legally tight with respect to all the aspects at the broader level and also at the detail level. Thank you so much for your time. Thank you. Thank you, everyone.